And we're going to talk about a fun topic, ending your legal career. How do you get out of this? And ironically, this morning we came out with the bar exam results. So I have a bunch of people who are focusing on the beginning of their legal career. In fact, we have 152 of them, if I recall, that passed the bar, and 33 who had a really bad day today. And some of you may remember walking up and looking to see that number, if it's on there, and then you went home and you came back later to check and see if it's still on there. People are going through that right now, and we had all sorts of calls, and I have the unfortunate position of having to meet with these folks next week when they come in to review their tests, why they didn't pass, and we'll talk a little bit more about that later on, but it should be a very interesting week. But now I want to focus on the other end. It's ending your legal career. How do you get out of this? How do you stop practicing law? How do you go and do the fun stuff? Right? Not that not practicing isn't fun. And what we're going to talk about is the new retirement option. I want to explain what that is, and the designated successor requirement. And we're going to talk about generally what it is, and then some specifics, how it applies to your practice, and then how it affects you. So it's going to be a general kind of overview of many things. And let's see if this isn't working here. So I'm going to just click over here. Well, retirement is the fun way to end your career. Right? In fact, when I was putting this together, I noticed that almost every picture when you Google retirement and images involves a beach. I don't know what the connection is because I live in Iowa, but there must be something that when you all retire and when we all retire, we want to go to the beach. So either that or it's a Cialis commercial. One of the two things when it comes in. So we're going to talk about the fun way to end your career. And I want to focus on some rule changes. And this deals with your status under the client security report. So when you file with us, you tell us, are you in corporate practice or government practice and those things. That deals with your status with our office. That is what you're allowed to do. And essentially right now, and you see this on the left-hand side of the screen for those that can see, we have really two statuses. We have what's called active, which I presume almost everyone in this room is probably active. But we also have inactive, which you can guess means the opposite. It's that you're not able to practice law. But we may have some people in this room that are inactive but are getting CLE. Okay, so there's a crossover there. Active is someone who can practice law anywhere in the state of Iowa. They have to file the client security and the CLE report and do the 15 hours and all those sort of things. An inactive practitioner, as we sit here today, is someone who cannot practice law. They can be inactive for CLE or client security. There's a choice we have right now. And basically, if they go inactive for both commissions, you don't have to file a report. Many people will go inactive for client security, but they keep their CLE active. And I see some heads nodding. That's pretty common. If you would call me up and say, Trey, I want to go inactive, I'd say, well, do you want to practice law in the next couple of years? And you say, well, I might. I just don't know. I'd have you keep your CLE active. Okay, that way you're kind of keeping things current. So then you just have to file a paper and pay some money to get back into active status. That's the distinction. But if you go inactive for both, you don't have to pay any fees. You don't have to file any reports. And you can reinstate to active status by basically filing some documentation with us. Now, you can never get rid of your law license as of today. Even if you don't want it, even if you run up to the judicial building and throw it at me and run away, you're still a lawyer, okay? More importantly, you're still an officer of the court, right? It means you're subject. You can't write letters to the editor and complaining about the judiciary or do this or do that because you're subject to as an officer of the court. So that's always been there. And you're precluded from certain tasks. If you're an inactive attorney, there's some things you can't do. You can't do tax returns, for example. You can't do lobbying without being an active attorney because those are the practice of law. That's how things are today. On January 1st, it's going to change. That's on the right side there. We're still going to keep the active status, so you're all going to be active. Okay, that stays the same. We're changing the name of inactive to exempt because I got tired of saying if you're in active status or in inactive status, and it got confusing. So I just said you're exempt. which the exemption comes from you file a certificate of exemption so you don't have to file the report. So you're exempt from filing the reports. That's where that language comes from. And we'll have a third category, which unfortunately is called retired. I prefer the term relinquish. And if I can change the rule here in a year or two, it's going to be relinquish. And you can say, my gosh, I heard Trey talk about that, and he did it finally. He made a change. The reason is many people want to retire from the practice, and you're retired from the practice of law. You think that means I'm not making any money, right? Or I'm not going to the office. But really, it's a status in our database. Right now, it's retired, and that's what we'll be using. But that will probably be changed to relinquish. And I want you to think of the term relinquishing because that's really what you're doing, is you'll be giving something up. In these three categories, active is the same, exempt is the same, but we're not going to have the CLE and the client security distinction anymore. You're just going to be inactive or exempt from doing everything. It just makes life a lot easier. And there will be a $50 exemption fee. Okay. To remain in that status is going to cost you $50 a year. And with that, you get the privilege of being able to reinstate and practice law. So if you are in active status, you're fine. If you go exempt, it's going to cost you $50. Basically, the money goes to help fund the system and goes in the general assessment and all that type of stuff. But the third category is the exciting one. That's the one that you get to basically relinquish your law license. You can now turn your law license over and you're free of being a lawyer. So you can't practice, but you can obtain what's called emeritus status. So even if you do this and you retire, you can still work for like Iowa Legal Aid and do some free pro bono legal work for them. We keep that alive. Or you can go to a different state and you're able to do that. And this is kind of the catch. In order to get your license back into active status, you have to take the bar exam again. Yeah. You guys heard that, right? You have to take the bar exam. 33 people's lives were ruined today because I sent them a letter because they didn't pass the bar exam. Okay. And so that's the big thing is you're going to lose your license. You relinquish it. You can't come back without sitting the bar. Now the question is, why would you want to do that? Why? Why relinquish your license? And it's actually a pretty good reason why you want to consider this. First, as an attorney who is exempt or inactive, you're precluded from doing certain things. You cannot practice law because you're exempt, right? You're inactive. But if you relinquish your law license, you're no longer an attorney. So you can do those things that you couldn't do before. Let me give you some examples. Tax returns. Okay. Drafting a tax return is not the practice of law when H&R Block or a CPA or a bookkeeper does it. But it is the practice of law if a lawyer does it. If you're an attorney and you go inactive, you cannot prepare tax returns because that would be considered the practice of law. If you relinquish your law license, however, you can do tax returns. Okay. Mediation. We heard Kim talk about mediations. You don't have to be a lawyer to be a mediator. Although if you're a lawyer, I highly encourage you to become a mediator and get experience, but you don't have to be a lawyer. So in my situation, as a lawyer who also is a mediator, I could relinquish my law license and still mediate. Lobbying, drafting articles of incorporations, all these things that you look at someone saying, my gosh, that's the practice of law. Well, it may not be if you're not a lawyer, but if you're a lawyer, it is the practice of law. We think this will be beneficial to those of you that have years of practice in an area and want to relinquish your law license, give it up, don't want to be a lawyer, you can't call yourself a lawyer anymore because you're not an attorney, but still want to be able to have some income coming in, want to have a life. Maybe you want to move to a different state and do some tax returns or help the kids or whatever. You can now do this under this. So it really opens up the door, and we have a lot of people at the end of their life or the end of their career say, you know, I really don't want to practice law, but I still want to do a couple tax returns for people. You have to pay all these fees to be in active status. Now you don't because you can be either, in this case, relinquish your law license, and you can still do those things. But remember, if you do this, to get your license back, you have to take the bar exam again. And the bar exam now is a lot different than it was back when I took it, 20 years ago, and probably when many of you took it. Things have changed. It's actually easier to get on an airplane than it is to get into the bar exam place. Okay, 'cause you have to have your stuff in a bag for security. I see some nodding heads back there. People that probably took the bar not too long ago. Man, you got a strip search almost to get in to take this thing. So it's very much has changed. But here's what I want you to do. If you're thinking, I want you to keep some things in mind. And this I put for those contemplating retirement. Thinking about the possibility of maybe retiring. Because I don't want you to commit yourself to anything right now, because I know how it could be when you're like, well, I guess I'll do it or I won't. But here's some pointers. If you'd call me up and say, Trey, what do I need to know? And here are the big issues. Number one, if you go inactive now, that is before the new rule takes into effect on December 31st. So if you go inactive now or December 30th or whenever it is, you fall under the current rule. And beginning January 1st, you're going to have what we call a legacy inactive status. Okay, a legacy inactive status. That is, I'm going to take everyone who's currently inactive on December 31st, and I'm going to push a button, and I'm going to change them all to legacy status. Those folks don't have to pay the $50 a year. Okay? And you have 5 years to decide if you want to convert to the new exempt status or what you want to do. Okay? So you can be in this category for up to 5 years, and you don't have to file any reports. Okay? So you don't pay anything, and you don't have any reports if you do it by the end of this year. If you go inactive after January 1st, or January 1st or after, I guess, to be technical, then you're going to fall under the exempt status, and you have to pay me $50 a year. But you still don't have to file any reports. My suggestion is, if you're thinking about retirement, you have to decide, how much is $50 a year worth? Okay. If you think you want to do it, and you're not sure, but you don't have any clients and you want to close things up, save yourself some money, file before the end of this year, and save $50 a year. You can always reinstate if you decide later on. If you're still not sure and you think, well, I don't know, maybe I want to keep it for a while, then go ahead and just realize that there will be this change on January 1st. So I get a lot of calls with people that are sort of on the fence, and, well, Trey, maybe I want to retire, maybe I don't, and I'm not quite sure. And this is really, the big issue is just this $50. Everything else is about the same. Because how you reinstate is about the same. And that's at the bottom there. How you reinstate. And this is really what's most important. To reinstate from either legacy inactive status or exempt status, so if you take inactive status at any time, you have to do the same things basically. Number one is you have to pay your client security fees due that year. So the disciplinary system fee and the client security assessment fee, whatever it is that year. So if you wait 3 years, you don't have to pay 3 years cumulative, it's just that actual year. And number two, you have to file a CLE report that shows you've made up the CLE for all of the years that you were inactive. So you have to have 15 hours every year. Every 2 years you have to have 3 hours of ethics. So if you're out for 2 years, then you have to show me that you have 30 hours of CLE, 3 hours of which is ethics, in order to get your license back, okay, to be reinstated. Now, you can do that CLE every year, coming to events such as Bridge the Gap or the annual meeting or any of the online offerings, or you can do it at the end if you decide, I want to reinstate now, and you can just do it in one big, immersion into CLE and get 40 hours done in 1 week. Frankly, that's my recommended way for people, is if you're going to retire, go ahead and retire. I mean, you're done with the practice, other than the social aspect of meeting people at these events, if you're out of the practice, be out of the practice. When you want to come back in, why are you coming back in? There's probably some economic reason. A great case has landed on your desk, or there's some reason why you want to come back. And there's a purpose why you need your license. Maybe it's to probate someone's estate or do a med mal or work comp or whatever it is. There's some reason. And you're going to be behind on the law even if you come to these CLEs because you haven't been dealing with it on a daily basis. Why not take that opportunity and immerse yourself in that area for 15 hours, 30 hours, whatever it happens to be. So you walk into your new office, you're up to speed on all the changes. We may not get those when you come to CLEs like this and you hear about the changes in work comp, and okay, but it wasn't relevant to you. Now it will be when you're coming back to do work comp or whatever. So that's my recommendation to folks is if you want to hold off on your CLE, that's a good way to do it. And we'll work with you to make sure you can get to the programs you need. I'll help you find stuff in the country that you can go to programs, and the Bar Association has worked well with us on finding different events and, heck, putting CLEs together to get you some CLE that you need. But think about that. That's really the difference between the two, is do you pay the $50 or don't you? That's the retirement classification. It's probably not going to affect most of you in this room right now. There's some people, I see some heads nodding, and people that have been thinking about it. But I wanted you just to kind of be aware of it at some point as to what this means. And before I go on to the next topic, are there any questions about retirement classifications and exempt and all that? Yes, sir.
I hate to ask a dumb question, but does retirement avoid Rule 3918?
Does retirement avoid Rule 3918? And the answer is yes. Okay, in 3918 is a succession rule that we're going to talk about. And once you retire, you no longer need a successor attorney because you're no longer practicing. In fact, if you go inactive, as you'll see, you don't have to comply with 39.18 as well. And that's a great segue to the next topic. Assuming there's no other questions on retirement. Okay. Well, let's talk about death or disability. I call it the not so fun ways to end your practice. Okay, we talked about the fun ways. These are the not so fun ways. I'm going to give you some bad news. In case you don't know, you are all mortal. Okay? You're all familiar, of course, with Socrates. There he's dying, and the famous syllogism. Any philosophers in the auditorium here? Okay, one hand. Anybody else taking any philosophy classes? Guys like Plato, Aristotle. You hear of those guys? Okay. Yeah, talk about this great Socrates. All men are mortal. Socrates is a man, therefore Socrates is mortal. Okay, we're all in that same boat. And philosophers from Plato to Aristotle to probably one of the most preeminent philosophers. Most of you probably know him. Vizzini, the Sicilian mastermind of The Princess Bride, even talks about this. Anyone seen that movie? You know what I'm talking about. It's inconceivable that you've not seen this movie. If you haven't seen the movie, by the way, this is your homework this weekend to go watch that movie because it's an awesome movie. Okay, and it kicks in. But yeah, we're all immortal. And some more bad news, you will be disabled. Okay, or statistically, you're more likely to be disabled sometimes during your life than you are to die. Excuse me. The likelihood of disability, which of course we can't see because it's like 1-point font on there. Basically, if you're 45, you have a 2-to-1 chance that you're twice as likely to be disabled than you are to die. And there's all these statistics I got at this fancy place on the internet with italic print over there. But basically, death or disability is something that is going to come to all of us either individually or through someone we work with or someone we practice with. And I can tell you that I know this firsthand because, as many of you know, on Saturday, Dave Ewert of my office, the assistant director in charge of admissions to the bar, he passed away suddenly of a heart attack. Died on a camping trip with his family. And talked to him on Friday. I'll see you on Monday, and he's dead on Saturday. And we're reeling with this, and those members of the boards that were here that knew Dave, he did a ton of work for the state. In fact, many of you probably have his name on your certificate to practice law. And he presided over your bar exam. Just out of the blue, he died, which put us in an interesting spot of having to not only deal with a horrible loss in our office, someone who's been there for 30 years in a very key role. He was definitely the number 2 guy, and some would say the number 1 guy because I'm pretty new on the job here. And we're dealing with his family, and we're dealing with getting into his office, as we'll talk about, to get the bar exam results. Okay? And I'm doing all this succession planning stuff, you know. So how can I make jokes about mortality when this is happening? Okay? But it's true, and it hits you when you least expect it. So it's going to hit all of you at some time in your practice. And that's really what I want to talk with you about. And that's kind of the whole idea. I don't want it to be a downer in this sense, even though it is some work, as Janice alluded to. But I want you to focus on this part of your practice. Now, some people, I've talked to a lot of people about this, and inevitably there's at least one person who says, Trey, why should I care about this anyway? Because I'm going to be dead, right? There's always somebody who's going to say that, and a couple of people are probably thinking that. And you're right. You are going to be dead, and you're not going to care. Okay? And if that's different, and if you die and you do care, please come back and tell me. Okay? But right now I'm assuming that once you die, you don't care about anything going on as far as your practice is concerned. Okay? You're looking at something else, or who knows. Okay? But it does affect other people. First of all, it matters to your family. Your family needs to be mourning you when you die and not dealing with me. Okay? This could be your spouse. It could be your children. It could be your parents. Okay? They need to be worried about where are we going to have the funeral and what songs are we going to sing or the celebration of life and food we're going to serve and gathering photographs and not dealing with me saying, hey, we need to get into the office now. Okay, we need to get in there and get, because they've got cases that are going. And our stuff, we're concerned about the clients. So it matters to your family. I'll give you an example. When Dave died, the bar exams had been tested, and he had the grades locked up in a secure drawer in his desk, locked up in his office, locked up in my big office, locked up in the building. I had the key to the front door of the building. I have the key to my office. I even have the key to his office because I'm the supervisor, right? But I don't have the key to his desk drawer that he had everything locked up in. That key was in a very safe place on the key ring in his pocket. On his body at the funeral home his body had been taken to. Okay. And so how do I get the key to open the door to get the bar exam results that we had to go to issue out on Friday? Well, his wife, who's obviously distraught, right? She just woke up with her husband there. She's got to come down Monday, and she forgets the keys. So she doesn't have the keys. How do we get them? So finally, I get the building, and we start jimmying open the lockers using what's that thing called? Crowbar to get the door open so I can get the bar exam results. Because obviously people are sympathetic that someone has died, but by gosh, they want those bar exam results. Because their whole life is depending upon that. It's a classic example of something that hit our office, and if we're not tuned in the succession planning after me doing all these presentations and materials and us promulgating the rule, who is, right? So it hit even with us being aware of this. It came out of the blue, and that's what's going to happen. The easy ones are when you have someone who's sick and dying, and you can make some plans, and you know it's just a matter of time. The hard ones are the ones that come right out of the blue, and you don't even know what's going to happen. And that's what we want to kind of protect you from, and your family. Dave's wife didn't need to be dealing with me in the bar exam. She needed to be doing more important things than dealing with this, but I had to bother her at that time. It matters to your clients who have lost the lawyers that they trust. And let's be honest, the client comes to you because they trust you. You're helping them through one of the most important events of their life. Breakup of their marriage, their liberties at stake, they're buying a house, they're adopting, they have work comp injury, whatever it is, they trust you. And by gosh, you are the best lawyer in the world at that particular moment. Okay, you start to suck after you've done with the case and you send them the bill, but up until then, you're the best lawyer ever, and they trust you. What you tell them to do, they're going to do. That's why they hired you. And now you've died. Who do they trust? I mean, they're now in mourning and have to deal with some of this stuff, and their concern is rightly saying, who's going to help me get my kid now? You were the best attorney I picked, and now you're gone. What did you plan for that? I mean, what do I do? It matters to your friends. Okay? Fact is, if you die, you're dead, but your friends, they miss you. And they're also the ones that are probably going to be contacted by your family to come fix the mess. Okay, we don't know. Call Tom. Okay, Tom will fix it. Now your friends have to go into your office and try to figure stuff up because they're your friends, and by gosh, they're mourning your loss too, but now they're being asked to do some other stuff. And it matters obviously to your colleagues, those you work with, those on the other side of cases. Okay? I mean, you can be ready for the most, the trial that's coming up. You've been working for 4 years, and 2 days before trial, someone on the other side dies. That trial ain't going. Okay, it's being postponed. Of course, it's going to be postponed. I mean, and everything is thrown in. So you owe it to all of these people to really kind of focus on this area on your practice. And we want to make it easy. Because I get the phone calls from your family. Okay, your spouse will call me. So-and-so's died. Eric's passed away. I'll pick on Eric here. Okay? Eric's died. I'm not predicting this. I'm just, okay. What do we do? Who do we call? Okay. He's got an office. I'm not even a lawyer. Can I look at stuff? What should I do? Or there's money in the trust account. Can we spend that? I mean, all these things. So we've got to get people in there right away to start to help the family, help the practice, help the clients. And that's really what this rule is all about. 39.18, which will be beginning in this filing season. So when you go to file your client security reports, there's going to be some new questions. And the client security report is the one that says, do you balance your trust account? Do you have signature authority? You remember all those little questions, and you click off yes, 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 no. Who would put no on that one? All that kind of stuff. Okay, there'll be some more questions on there, and I'll show you one or two, but they're real basic questions. We want to know, who do we call? When I get the phone call from your spouse that you've died, who do I call to let know? Who's the person that you've talked to about this and said, hey, if something happens to me, can you step in and help my wife or my kids or my friends, or my colleagues, help resolve this practice for me? I don't know who you know. I mean, if you don't give me a name, I've got to get a hold of the chief judge in your district, and that judge is going to pick an attorney at random who will be appointed the trustee who's going to come in and do it. Okay. They don't know who you are. They don't know anything other than they now have to go and they have to resolve this mess. But if you know someone that can help you out, let us know. That's what a successor is. Just someone I can contact. Now, the first tier, all attorneys in private practice have to complete this. The first version of this rule said all those solo attorneys. Now, if you're in private practice, you have to comply with this rule. If you're in a government practice, then presumably you have some sort of succession plan. If you're corporate practice, you probably do. Okay. But we're focusing on private practitioners. It doesn't matter if it's one of you or 1,000 of you in the firm, you have to comply with this rule. Now, how you comply is a little bit different depending on the type of practice you have. If you're a member of a firm with 2 or more Iowa lawyers, okay, yourself and somebody else, okay, you can designate the firm. I don't need a name. I just need to know I can call the firm. In the firm, presumably you've figured this out, okay? I just want to know who to call. But if you're by yourself and you don't have a firm, then you have to give me a name, as we'll talk about here in a second. If you're an Iowa attorney who's not practicing in Iowa, you don't have to comply. We have a number of Iowa lawyers who live outside of the state and they don't practice law in Iowa, but they keep their license up. They don't have to comply because they're not practicing in Iowa. That's another state's problem. I got enough problems the way it is. I don't need to deal with theirs. So, it will be part of the annual security requirements. Each year you have to list this person. And if you change, you have to supplement after 30 days. So if you add a new person, you just have to supplement, as with everything else. We try to make it consistent with all the other client security stuff. Now, there's this optional second tier that deals with a written plan, and we'll talk a little bit about this later on, but basically this allows you as the attorney to enter into a contract with your successor attorney, and I'll talk about why in a second, that basically delineates what they can and can't do. And we'll talk about that here shortly. It gives guidance for law firm management. And it's really the distinction between a trustee and a successor, as you'll see. You don't file those documents with us. There's something you have. It's a private thing between yourself and your corporation and that successor. The Bar Association has come up with some great documents. They're very legalese. Okay? They don't have to be legalese. They just have to be legal, and they're available on the Bar Association's website. Yes, sir?
Just a quick question. If you designate someone as your successor,
Great question. The question is, if you designate someone as your successor, do you then have a conflict with that person in other cases? And the answer is no. Because the successor plan does not kick in until after you've died or been disabled. So there's no conflict there. Now, a possible conflict could arise if that person becomes your successor and you still have that ongoing case. Yeah, then they wouldn't be able to take that case. So the conflict is out there, but just the act of designating does not create a conflict. Good question. So this is what the planning attorney has to do. This is what you have to do if you're an attorney and practicing in Iowa. Okay, you have to designate one of the following people, or one of the following, I guess, not really people. It could be an active Iowa lawyer. So you have to designate an active Iowa lawyer, or a law firm with an active Iowa attorney. This is a great business opportunity for some young law firm that start up and say, I'll be the law firm that will wrap up your practice. So a law firm doesn't have to be your firm. It could be another firm. It could be a qualified attorney servicing association, which is a fancy way of saying a bar association of Iowa lawyers that has agreed to do it, and we'll talk about that in a second, or a professional liability insurance company, malpractice carrier, that has agreed to do it, or third, an Iowa bank with banking division trust powers that has agreed to do it. And all three of those, you notice I put that little phrase, has agreed to do it. Right now, we have no entities that have agreed to step forward as of today. Next week, I'm meeting with the Board of Governors. The Bar Association of Iowa is mulling this over right now, so they're working on it. Local bar associations are mulling it over as well. What are their obligations and requirements? I think we're going to see a lot of folks in the substantive bar associations, IAJ, the workers' comp folks, criminal defense bar, they can do this as well. And so we're very early in the process, and they're all deciding if they're going to be entities that their members can name. So right now they have to consent, okay, and you need to talk with them and give them a call and say, I'm interested, or watch your mailings when things come out as they're all deciding. The same thing for professional liability insurance carriers. In fact, earlier today I was speaking at another CLE presentation with MLM, had their folks there, and they're deciding if they're going to do it or not. So contact your malpractice carriers and see if they're willing to step into that. These are all, the idea is to give you as many options out there of people that can step in as there is. So bar associations, carriers, banks, and law firms. Yes, sir? Well, yeah, why do we put banks in there if none of them wanted to do it? That actually came from the Bar Association's task force of different entities that might be interested in doing it. And some of the banks, they're interested, and they have a bank that with trust powers, because you're really acting as a trustee, as you'll see here in a few slides down the road. And some of the banks, and there were some banker lawyers who were involved in putting the rule together, thought that banks may want to get into that niche area of business. Right now, people are sitting back and thinking, okay, what do we have to do? What's our risk? What are we going to charge for it? And they're making that decision. So now they have to decide if they're going to be in or out. Same thing for bar associations. I mean, they're doing a cost-benefit analysis. What's the obligation? And so the thought was, let's put it in the rule that if anyone wants to do it and they're willing to raise their hand and say, we'll do it, then you can do it, rather than not have them in the rule and then they can't do it if they want to. You must also designate 3 other people, or it could be 1 other person, depending on how it works out. And these are called the custodian lists. Basically, we need to know who has or knows where your client list is, that is, your list of active clients. Now, most of you probably have a list of active clients. These are the ones you're actively working on. But there's some attorneys who don't. Some attorneys, they keep it all in their head. Or it's on index cards, or it's in QuickBooks or whatever. I don't care how you keep it. Write it on eggshells. It doesn't matter to me. But just, I need to know who knows where it's at. So when I get the phone call that you passed away, I can tell Bob, hey, go look in the second drawer on the left because that's where they keep the client list. Okay, that's all what that's about. And the same thing with electronic and paper files. Where are your files kept? Most people keep them on site, but you'd be surprised. Some firms, The lawyer keeps them back at their house. They're in the kitchen. Or maybe the off-site files are down the road in Uncle Fred's barn. I mean, so nobody knows because you've died. I mean, we need to know where to find those clients' files. And last is who has the password and security protocol to get into your office. Okay, that may be who knows your screensaver password or your account numbers to log into your trust account if you do your online banking. And maybe you have a OnePass or a MasterPass account, which is a great idea for all your online things under one secure thing. But someone ultimately is going to have to get in there. We can do it eventually through trust powers. Okay, just like if you don't have a safety deposit box, we can drill it out and we can pop the lock that way, but it takes more time. Now these three people, they don't have to be lawyers. In fact, oftentimes they may not be lawyers. They could be your staff members. I don't know who's on your staff, so who on your staff knows where this stuff is? It could be a spouse, it could be a friend, someone that just knows this. I think for the passwords and security protocol, it could be one of your kids, right? They seem to know how to get in everything anyway, right? So maybe they can figure it out. We just need to know, who do we tell the trustee or your successor that they can provide help to you and information? Yes, sir.
Does the second point there, electronic and paper files, does that relate to the active client?
Great question. The question is, does the electronic and paper files relate to the active clients? I'm going to go so far as to say it relates to all of your clients.
What about somebody who did an estate plan for 5 years?
Yep. What about someone you've done estate plans for 5 years or 10 years or 15 years? That person needs to know where your files are for active clients and the past files you've had. So typically we find that most people keep their active files in their main office and they have a storage someplace. Nick and I had it down in the basement in storage room 5 and 7. That person just needs to know that the old files are kept in 5 and 7. Okay, and the keys found in the drawer. It's that type of thing, because oftentimes those are the files that need to be returned to clients if they're older than 10 years and following the guidance that the bar has. And where are they? We don't know where they are. And so that person needs to kind of know where your files are. This is an example in 1-point font of what the client security questions look like. You may recall just the shape. Remember the yes, no, yes, no. And I'll show you just kind of what you're going to, when you log in, you'll see something like this now that will be one of those questions that say basically, who has to answer it. And we're going to have questions 25 through 30. And again, I'm just going to flip through these. There'll be questions like this. I didn't want you to be surprised when you saw them on the form, but they say things like, I am engaged in the private practice of law in Iowa. If you hit no, it skips to the end of it. If you hit yes, then you answer the other ones. Just type in the name and the address. I forgot to put email on there too, but it's just a simple form. You can always log in and change it. There's always ways to update it if you need to update it. But this information will be in our database, so I know who to contact. And more importantly, let's say that you call me and said, Bob, of whom I was a successor attorney, has passed away. I can print off a designation sheet that you can take to the bank that will prove that this person, you've been designated, you're almost a de facto trustee. Go to the bank, it's been certified, and the bank will honor it and get you in the trust account and that type of stuff. Now, many of you are going to be asked to be trustees. I know some of you are going, I'm in a firm already, I don't have to worry about this because I've got my firm will take care of it. Well, here's what's going to happen. As we get closer to the filing season, your old law school classmates are going to call you up and say, hey, I got something I need to ask you. And you're like, oh gosh, I don't want to be guardian for your kids. And I say, no, it's not that. Will you be the successor for my practice? And you're going to say, I don't know anything about workers' comp. I went to one CLE and I kind of dozed through the whole thing. I know there's a new rule change. No, you don't have to run the practice. You just need to be the successor. And you're going to think, well, I don't know, what does that mean? What do I have to do? And that's really what these next slides are going to cover. We're going to talk about the difference between a trustee and a successor, then what duties that you're willing to undertake, and then last, what you want them to do before you decide yes or no, and then what other stuff we have time for here. So, trustees and successors. There is a difference. I call this trustee and successor 101. Most of you probably know a lot more about this than I do, depending on the type of practice, so please overlook the easiness. But there's a couple of you I think maybe don't know the distinction as much, how it applies in this particular situation. A trustee is someone who has no interest in the trust property and cannot benefit by the exercise of the trust powers. They're a very impartial, independent person. They're a trustee. Fiduciary obligation to go in and, can't self-deal and all that good stuff. A successor is someone who stands or steps into the shoes of the predecessor. That's the successor, right? So you're not a trustee, it's different. And here's how it plays out. A trustee is prohibited from taking any of the cases or clients of the attorney for whom they're the trustee. So if you're appointed to be my trustee, and I've got 4 or 5 really good cases, if you're the trustee, you can't take them, because that would be benefiting from your position, right? Your only job is you have to send those cases to somebody else. You farm them out to other people. Okay, that's all you can do. A successor, however, can keep the cases and the clients. Obviously, the clients have to agree. The clients always have the choice where they want to be. But if you're doing med-mal cases and I'm doing med-mal cases and I die and I've got 3 or 4 good ones, right? You want those cases, well, then you can take over the cases. And chances are the clients will probably agree because they were the lawyer that I trusted, or they trusted me, and I've trusted you, so there'll be some carryover there. A trustee cannot be involved in any of the firm operations. So a trustee can't make payroll. When you die, what happens is your workers still want to get paid. Well, a trustee can't get into the general account and make payroll. They can't do all that stuff that needs to be done. A successor can. A successor, if you have the proper agreement, that written contract I mentioned, that tier 2 level, they can make payroll for your people. They can, pay the bills and keep the lights lit and all the type of things that need to be done. They're able to do that. They can hire staff. So let's say that, that Eric's passed away, and I know that once again, and his secretary, Linda, is really good. I can hire her. Because I don't have a trustee relationship, it's a successor relationship. So I'm able to hire his staff, and they get that really cool desk that I've always wanted that he has. I can buy that from his estate and all those things. A trustee can't do any of that stuff. And before you think that's outlandish, think in most rural areas in Iowa, when one of the lawyers would die in a small firm, other lawyers from that town would step in and take over the practice, which may include the building. Right? Maybe you have a young lawyer who takes over the building, the books, all those things. That's the succession plan that was contemplated. The trustee, is the best option for you if you want to get in and out of something. And I suggest to people that if you don't know anything about that person's practice, the type of cases they do, or you don't want to do anything with the practice, then you want to be a trustee. You want to get in, farm out the cases back to the clients, pay them back the money in the trust account, and then you're in and you're out of the whole thing. Okay. A successor is best if you want to expand or increase your practice. So if the person has a similar practice to you, or you want to expand into that area, by being the successor, you're allowed to take over that practice and incorporate it in your own. Now, there's some more liability on that side, but there's also more gain, as we'll see. So those are the 2 concepts we're going to go through, trustee and successor. And the rule contemplates both. The rule contemplates both. So the comparison of duties, you'll see the ones that are underlined are really the only things that are different between the 2. So even if you can't read the small print, you can see that they're basically the same. The trustee and successors have to contact the custodians to obtain access to the office and the files, notify the planning attorney's malpractice carrier of the death, notify the courts and tribunals where the planning attorney practiced, notify the active clients of the attorney's death, administer the trust account, and then, of course, return files to the clients. That's what the trustee does, wraps up the practice. The successor is the same, except they have to also determine if other actions are necessary to protect the client's interests. So they have to take a look at the file. Maybe that's when they'll discover there's a conflict, for example. Or maybe there's a pending statute of limitations. They have to take some action. So there's a greater risk put on the successor attorney. The benefit, of course, is they get to keep the files and keep the cases. So the idea is, okay, if you're going to have the opportunity to keep the cases and the files, then you have to have some responsibility to those clients. And you get to decide, as the successor, the person named, you get to decide which one you want to be. It's not me, the dying attorney, who points you that. You get to make that determination, as you'll see. But I wanted to show out the differences between the two. So they're almost the same, but there's a slight difference on the responsibility of the successor. Okay. And there's a difference on money, because let's be honest, you probably don't want to do this for free. This is, you're taking over someone's practice, you're helping them out. Okay. The first thing you're going to get is you get paid through the adoration of your peers. You're a great person. Okay, we thank you for helping out the bar. And believe it or not, the vast majority of trustees that get appointed waive their fees because we want to help out our fellow members of the bar. And we're going to step up. So that adoration of your peers actually is the number one way that most people get paid, because we do thank you for all you do, and everyone thanks. The court system runs so much better, and the legal profession in Iowa is great, particularly compared to other states. I mean, we look out for each other. That's that first one. But if you're a trustee, your fees become a claim against the estate. I don't know where they rank on the bankruptcy or the probate scale, but I think they're pretty high, and we're going to make them even higher. Okay, because these are the fees in wrapping something up, and the court's very cognizant of the fact is we need attorneys to do this and help out. So your fees become a claim against the estate. If the estate can't pay them, there are insufficient funds in the estate, then you have a remedy where you can make a claim against the Client Security Commission. You know, that $50 we all pay out every year to the Client Security Commission to basically deal with funds that people, funds paid out in claims from clients who's had their money stolen by lawyers, defalcation aspect. We also pay out trustee claims for that. So if you can't be satisfied, you can put the claim against the Client Security Commission, and they can consider some amount of reimbursement on those claims. If you're a successor, you will obviously still get the adoration of your peers, but you also get the clients and their cases. So you're inheriting a lot of business. Obviously, the clients have to agree. Right? Your successor fees can be the subject of a contract. That written contract we talked about, you can have a provision that says, I will wind up your practice, the business side of your practice, and all the winding down and buy and sell real estate and all that good stuff. And it's going to cost you, $200 an hour or whatever your fees are that you agree. And that certainly becomes a claim then with the estate that you have. But you can't make a claim against the Client Security Commission because you're not a trustee. We can only pay trustee claims. The thought being, if you're going to be a trustee, we're going to pay you for your services, through one of these. But if you're a successor, you benefit by getting the cases. You get the clients. And that was kind of the way, the balance, I think the court and the task force and everyone came down as being fair. You have the choice, but you can't choose both. Now, you don't get to decide today and don't have to decide today. If I call you up and say, will you be my successor? And you say, yes, I will. You don't have to decide if you're going to be the trustee today or the successor today. That's a decision that gets made once you become activated. That is, once I call you and say, hey, Eric's died. Okay, sorry, Eric. No, Eric's died, okay. What do you want to be? We'll talk about it at that point. Because your life may have changed between now and then, right? Your practice may have changed. his practice may have changed. And it's not fair for you to lock yourself in on one and not know what to do later on. So you have the ability to change your mind. You can decide, I want to be a trustee, then later on you may be a successor. It really depends on what you want to do. So you get to decide further down the road, but you can't be both. So I know some of you are going, I know, I'll be the successor and take the good cases and then become a trustee and get rid of all the crappy ones. That doesn't work that way. I'm on to you, okay? So you're one or the other, but you can't be both, and you can't be one and then the other. Okay, so if you're in for the cases, you're in for the cases. That's the only fair way we could do it. We want to help people out, but we can't have you poaching stuff because then everyone's going to take the good cases and not deal with the other stuff. That's kind of a headache. Let's be honest. We all have a couple of cases, except for Karen, that are kind of dog cases we shouldn't have taken. Right? So you have to deal with those cases too. Now, before you say yes to being a designee, okay, when you get a call from that law school classmate or your neighbor or your fellow professional in your building, I want you to have them do a couple of things before you commit. Okay. This is in your best interest, and frankly, it's what they're required to do, and it will make life better for everybody. Okay? So they're calling, asking you for help, so you can say, well, I'll help you, but you got to do a couple of things. Number one, ask them to start making an active client list, right? Presumably they're listed who the custodian is, but if they don't have one, have them start making one. Okay, make one. I need to know who your active clients are. And that includes things such as what court is the matter in? Is it in federal court? Is it the Northern District or Southern District? Is it in Iowa? Is it a work comp case? Is it an employment thing? I mean, what tribunal are they in? Get some data on that. Just not a name and a number. I mean, make a little more information, and you can make that call. We don't have any rule on what the active client list looks like. You can make that call, what you'd like to see on that list, because they're asking you to take over their practice as a trustee or successor if they die. So you can ask them to have at least a list that can help you. Ask them to start an inventory of original documents. Some of us have very few original documents. Some people have original wills that they've written and they keep it. Just inventory those so you know where that list is and so what's an original document. Yes, sir?
You probably couldn't give that because some of that would be confidential.
Well, you're not giving it to them. You're just having them prepare it. Yes. The question is, can they give the active client list and the things to you? No, you're not even going that far. They just need to prepare it and have it prepared because the designation of the custodian will be who has that list. So who do you contact in their office that has that list? I just want to make sure they actually make the list. Because when you show up there and you say, okay, Cindy, where's the list? And they say, oh, they never actually made the list. Now you're stuck having to create a list of active clients. So you can certainly say, could you start to make an active client list? You have one made? You can call the shots on anything you want. They're asking you to do something for them. Having them at least make a list is something good. But you don't want a copy of the list. It's going to change, right? New cases come in, but you need to know where it is, and they need to be making one. Ask them to start purging the old files, kind of tied into this question here. Any file over 10 years, there should be a very good reason why they're keeping it. Okay? If you have files that are over 10 years, the fact is there's either some specific reason why you have it, or let's be honest, we're just lazy and don't want to take the time to get rid of them the right way. And there's a bar association opinion that comes out as to how to do it, giving notice. I mean, you shred them, you can scan them in. I mean, it's all there, what you have to do to give notice ahead of time. Start doing that and ask those people to start getting rid of old files. Because it's hard enough when you're stepping into someone's practice to now you've got to deal with files that are 20 years old, 30 years old, and how do you handle them? What do you do with them? When they could take the time to get rid of them and make your life a lot easier. Yes, sir? Great question. Is there a definition of active client? And there is not one yet. And here's why. Paul Week, and many of you knew Paul, my predecessor, Paul and I had some fun discussions on what's an active client list. Because as a trial attorney myself, I looked at clients as cases. Someone would come to me, I'd try their case, and I'm there for that legal matter that I'm fixing it for them. And once it's done, I never see him again, right? You only have one PI case or one med mal case, it's over. Everybody gets one wrongful death, right? Okay. For Paul, he was looking at from the rule practitioner, from an office practice, that a client is someone who considers you to be their attorney even though you haven't done work for them for 2 or 3 years. Maybe do the taxes once a year, or, you know, if they're going to buy property, by gosh, you're their lawyer. You know, they're your client, and they'd be upset if you went to somebody else. So there's a slight difference between the two. I've asked Nick to put together an opinion from his committee, the Iowa State Bar Association committee, to give some guidance to lawyers as to what's meant by that, because it's different depending on the type of practice. The rule leaves it very vague. We don't get into the specifics, primarily because of these differences. In my mind, I look at it this way. If you go back a few years before we changed the advertising rules, you had a 5-year window or so that you could contact former clients and basically solicit their business. You could ask them and say, hey, I'm a lawyer, send me some more cases, it's been 3 years since I've talked to you, and they fell in that client list, right? You couldn't just send a card to somebody you didn't know and ask for their business because that's improper, but clients you could. And that was about a 5-year period of how old those clients could be before they sort of fell off that list. So my rule of thumb is just kind of using that, is who's on there. But frankly, what we're dealing with right now on the active client list are who are the matters that you're actively dealing with in your office. Because that's really the key. When I step into your practice, what are the 10 things I need to look at? Now, I know you've got 50 other clients that maybe you'll do their tax returns. Okay. But right now, what are the 10 that I really got to deal with? Because those are the ones I need to notify that I can't finish the job. Okay. The others are going to be notified as well when you give notification to all the clients to come get their files. They'll find out, but it's probably not pertinent. Some of you doing tax, think about it. I mean, this happens a month before tax season. Man, you got a whole list of 400 people. 2 months later, maybe it's down to 20. So it's going to vacillate up and down depending on the type of case. Ask these people to make, or whoever is designating you, to make a WID plan, when I die plan. A WID, that's a great acronym, right? So when I die, this should be something that they have that when you walk in their office and go, oh man, why did I say yes? What do I do? You can pull this out, and it has things like their malpractice carrier information, if they have malpractice insurance. Who's their carrier? How do you call them? Where their trust accounts are located. They're in Smith Bank or this bank or whatever. Maybe they have more than one. And any other things that they think you should know. Maybe there's some stuff they want you to alert you to as to this or that. Kind of like in a will, you always had that, and all my personal possessions will be distributed by this list, which can be found in my second drawer, and you modify it, that type of thing. Something just giving you advice of things that you may want to know for your benefit to help out. And last, if you want them, or if they want you to help wind down their business practice, that is the business side of the law practice, make payroll and that sort of stuff, then you're going to have a written agreement. And again, the Bar Association has a form because it's just not the lawyer, it's also the corporation has to sign off on this. And so you need something in writing to protect you so you know what powers you have and what you're able to do. Now that's outside of the scope of what I care about. Okay? I don't care about this sort of stuff other than to alert you to the fact is you need to have some agreement so everyone's on the same page, that you have the ability to act on behalf of the PC, and you know what you're supposed to do, and you have all the powers, and so you can do those type of things. So again, that's something that's, if you want to go down that route, when your designee asks you, say, okay, I'll do that, but here's what it's going to cost. Here's what it's going to take, and so everyone's on the same page. Now, all of you, as planning attorneys, before Christmas, because I know you don't really have too much to do between October and November and December, right? Here's some things that you can do. And I suggest you do these things even if you already have a law firm that would step in and take over your practice, such as in my case in our office. And those of you that already have firms, our firm's taking care of it. Okay, here's some things you can do that you will benefit. But most importantly, if you're an attorney in solo practice, okay, things you can start doing as you start gearing up. First, get written confirmation of who your successor attorney is going to be. Get it in writing because people will forget, right? Send them a letter, send them an email. Okay. Make sure they really want to do it. Make a list of your relevant usernames and passwords. Okay. Lock them up and use MasterPass or OnePass or whatever it is, or a spreadsheet. I don't care. Just start making a list of these things so someone else knows how to get into it. Ensure your staff and software can produce a list of current clients. Minimize the original client documents you have, okay? Wills and abstracts. Return them to the clients if you need to, or index the ones you don't return. Some people hold on to those things. There's no right or wrong, but index them so someone can find them later on. Purge the files you don't need. Go through your files and make that your goal to do by the end of this year is you're going to get rid of 5 boxes of files and handle them properly. Get into the system of getting rid of it. You'll feel so much better once you do that. Create that when I die file directory or folder or document for the person that steps into your shoes from your own firm even. so they know what to do. Like, I would love to have stepped into Dave's office and found a file that said, what to do when I die. I'm like, oh, yes, thank you. Okay. There was nothing like that, so we're trying to build it up. So we can all have something like that. And last, again, if you want your designee to wrap up your practice, enter into an agreement, a contract with them, so you're able to do those things. So that's, in summary, that's the end of how to end your legal career, both voluntarily and involuntarily. I've got the stop sign here, but if anyone has any questions, I will remain afterwards, because I want to let everybody else go and just come up and I'll answer all your questions as long as it takes. On behalf of the Bar Association, thanks, and on behalf of the court, thanks for your attention to this Rule 39.18. Thank you.